Thank you for utilizing the Council on Developmental Disabilities as a resource. This presentation is provided through the support of our generous donors, as well as the Louisville Bar Association and Metro United Way. Thank you. Information in this presentation was compiled through resources from the Jefferson County Attorney's Office, the Kentucky Guardianship Association, and the Kentucky Revised Statutes on Guardianship, Chapter 387. This presentation is meant to support a person's understanding of guardianship and does not offer legal advice. Now, let's begin to explore guardianship and conservatorship in Kentucky. Today, we will attempt to explain and summarize the process to initiate guardianship or conservatorship, as well as the responsibilities to the court of an appointed guardian or conservator. What is guardianship? Guardianship is a legal relationship between a capable adult, the guardian, and a legally disabled person, the ward. A guardian is appointed by a court and given the authority and responsibility to make decisions which directly affect a person who has been determined to have limited capacity to act in his or her own personal interest. Guardianship is a support that is used as a last resort to protect the well-being of legally disabled adult citizens from neglect, exploitation, and abuse. Under U.S. law, all individuals are defined as adult at age 18 and allowed to make their own personal decisions at this age. For some individuals, despite their chronological age, they may not have the capacity to understand the implications of their own decisions regarding medical, financial, and/or personal affairs. As such, guardianship is a process through the court whereby an individual's capacity to manage their own medical, financial, and personal affairs are evaluated. Appointment of a guardian is taken very seriously as it is a legal process that can potentially take away an individual's right to vote, as well as to make one's own legal, medical, and/or financial decisions. Questions that are considered in determining whether guardianship or conservatorship is necessary are: is the disabled person able to provide adequately for his or her personal needs for physical, health, food, clothing, or shelter? Is the disabled person able to manage his or her financial resources effectively? Is the person going to be taken advantage of if no one is appointed to act on his or her behalf? Is assistance available through means other than guardianship or conservatorship? The process toward appointing a guardian or conservator includes filing petitions with the court, the appointment of counsel for the alleged disabled person, completion of interdisciplinary team evaluations, a trial by jury, and finally, appointment of a guardian or a conservator if the jury finds the alleged disabled person to be legally disabled. There are other supports to consider prior to initiating guardianship. These other supports are a representative payee, power of attorney, healthcare surrogates, and supported decision-making. We will take time to review each of these supports later in this presentation and will focus now on the steps involved in the guardianship process. Starting the guardianship process. Number 1, filing petitions with the court. The process of initiating guardianship or conservatorship starts with a person who is concerned about an alleged disabled individual. This concerned person could be a friend, a relative, a social service agency, etc. The concerned person, called the petitioner, files guardianship petition forms with the county office of the circuit court clerk. These forms are completed on behalf of the alleged disabled individual who is known as the respondent. The term alleged disabled is used because legal disability is not the same as medical disability and thus must be explored and defined through the court. The petitioner obtains the necessary forms at the county office of the circuit court clerk. All forms must be signed and notarized, which is a service available at this office. In Jefferson County, this office is located at 600 West Jefferson Street, room 3177, Louisville, Kentucky 40202. The office can be reached by phone at 502 595 4053. It is important to understand that legal disability is not defined in the same way as medical or physical disability. Kentucky law defines a legally disabled person to be one who is unable to make informed decisions with respect to personal and/or financial affairs measured by functional inabilities within the past 6 months. These affairs include, but are not limited to, healthcare, food, shelter, clothing, personal hygiene, as well as managing assets and property effectively. For example, a person may have a physical disability that limits their mobility, yet still has the mental capacity to make informed decisions about their own legal, medical, and financial needs. Likewise, a person may display unreasonable behavior or make rash and impractical decisions, yet not pose a risk to themselves or others. Having a mental disability or simply having bad judgment does not necessarily mean such a person will be determined legally incompetent and in need of a guardian. A few additional terms that are helpful to define. A fiduciary is a person who holds a legal or ethical relationship of trust with a person or group of people. Thus, guardians and conservators are fiduciary. A guardian is a person who has been appointed by the court to manage all or part of a ward's personal and financial affairs. A conservator is a person who has been appointed by the court to manage all or part of a ward's financial affairs. A ward is a person who has been evaluated and found to be legally disabled with an appointed guardian or conservator. It is the court that has the authority to appoint a guardian or conservator, and thus the court's responsibility to assure the appointment is proper and that the ward's affairs are adequately handled. Responsibility of guardianship and conservatorship ultimately remains with the court. Guardians and conservators act on behalf of the court and must report back to the court to account for their work. These reports assist the court to monitor the ward's care and well-being. We will talk more about the responsibilities and obligations that a guardian and a conservator have to the court later in this presentation. But first, let's continue to look at the initial forms that are completed by the petitioner to initiate guardianship. Upon going to the county office of the circuit court clerk, the petitioner will ask the clerk for forms to initiate guardianship. The clerk will then share a packet that includes several forms. These forms can be completed by the petitioner or hire an attorney to assist with completion. It is not required for the petitioner to hire an attorney. One form to be completed is the petition to determine if disabled. Completing this form is a formal request for the court to define the respondent's capacity to make informed decisions, to help determine if the respondent is legally disabled. This form can be found online at the following address. This form requires the following information: the name and address of the petitioner, the name and the address of the respondent, the respondent's date of birth, social security number, driver's license number, sex, race, height, weight, the nature and degree of the respondent's alleged disability, a statement as to why guardianship is being requested, the value of the respondent's assets if known, the name and address of the respondent's next of kin, the name and address of the respondent's durable power of attorney or healthcare surrogate, if applicable. Another form to be completed is the application for appointment of fiduciary for disabled persons. This is completed by a person who wants to be considered for appointment as the respondent's guardian or conservator. Information required on the application for appointment of fiduciary for disabled persons. Nature of the applicant's relationship to the respondent. The applicant's qualifications for appointment as a guardian or conservator. The applicant's name, address, and phone number. Surety on bond. The value of the respondent's assets if known. And there may be more than one application for appointment as a guardian or conservator. This form can be found online at the following address. Once the initial forms, including the petition to determine if disabled and application for appointment of fiduciary for disabled persons, are completed, they must be signed and notarized. The petitioner can sign these forms in front of the disability court clerk who will notarize them, or use another notary of the petitioner's choice. There is a fee to file these forms with the court. In Jefferson County, the base fee is $68. Once the initial petition and applications are filed with the court, the person who is alleged disabled is appointed counsel, also known as an attorney. This type of counsel is called a guardian ad litem, or GAL for short. A GAL's role is to protect the rights of the respondent during the legal process and to represent the best interest of the respondent. It is important to note that counsel is not provided to the petitioner or guardian conservator applicants. These individuals can hire their own counsel if desired, but it is not required. After the court receives the petition and assigns the respondent and GAL, the county's attorney's office will assign an interdisciplinary team to evaluate the respondent. Evaluations are needed to provide information to the court about the respondent's capacity to understand and make informed financial, legal, medical, and personal decisions. An interdisciplinary team comprised of a medical doctor, a psychologist, and a social worker will be hired by the court to complete the evaluations. The medical doctor will evaluate the respondent's current medical condition in light of their ability to care for themselves and manage their care. The psychologist will evaluate the respondent's mental capacity to care for themselves with their current needs and demands of life. The social worker evaluates the respondent's home environment and ability to function and care for their person and property. All three professionals write individual reports with information related to the respondent's medical, psychological, and personal needs. These reports are the property of the court and are used to inform the court of the respondent's capacity to understand and make informed decisions. In the state of Kentucky, guardianship is determined by the court through a jury trial. Kentucky is the only state in the Union to determine guardianship this way. According to Kentucky law, KRS 387.550, the jury trial must be scheduled within 60 days of the date when the initial petition was filed. At the trial, a 6-person jury will utilize information from the interdisciplinary evaluation reports, the county attorney, and/or others present to decide if the respondent meets the criteria for legal disability with regard to management of personal affairs and financial resources. If the jury determines that the respondent is not disabled or partially disabled, the petition will be dismissed. Alternatively, the jury may find the respondent to be completely or partially disabled and may recommend full guardianship or limited guardianship or full conservatorship or limited conservatorship. Following the determination of disability by the jury, it is the responsibility of the court and judge to decide which specific rights the respondent is now unable to legally recognize with respect to financial management and personal affairs, voting, driving, etc. It is also the responsibility of the court and judge, not the jury, to appoint a guardian or conservator. All pending applications for appointment of fiduciary for disabled persons will be considered. The court may hold a separate evidentiary hearing to determine who should be the guardian or conservator. If no one applies to be the guardian or conservator, the courts will appoint the Cabinet for Health and Family Services as the guardian or conservator. Upon the judge's ruling, a judgment will be written that specifies the powers and limitations of a ward's guardian or conservator. If a determination of partially disabled is made by the jury, the ward retains all rights that are not specifically limited on the judgment. A determination of fully disabled does not deprive the ward of the right to vote unless specifically stated in the judgment. Once appointed, a guardian or conservator has responsibilities to serve both the ward and the court. However, being appointed a guardian does not give absolute control over every aspect of a ward's life. The guardian will need to utilize the court for guidance when difficult ethical issues arise, like medication compliance or need for inpatient mental health treatment, etc. There are resources available to guardians and conservators to better understand how to carry out their responsibilities to the court and to their ward. The Kentucky Law, Section KRS 387.640 through 387.670 can be searched online. The Guardian and Conservator's Handbook can be accessed through the County Attorney's Office, and one could choose to become a member of the Kentucky Guardianship Association for access to their printed materials like the Manual for Guardians and Conservators. A guardian's duties to the ward include protecting the rights of the ward, formerly known as the respondent, supporting the ward's personal development and maximizing independence in the least restrictive way, establishing and maintaining housing, providing for social, educational, and physical needs, providing consent for medical and mental health treatment, managing finances like banking, real estate, and bill payment. The guardian's duties to the court include filing the 60-day inventory, filing the annual report of guardian regarding the ward's personal care and development, filing the periodic or final settlement of guardian or conservator. This form is informally known as the financial form that is filed at least every 2 years. All required forms can be found online at the following address. Let's talk in more detail now regarding each of these forms. Within 60 days of being appointed a guardian with financial responsibilities or a conservator, an inventory of the ward's estate must be reported to the court. This information is reported on the 60-day inventory, Form AOC 855. On the 60-day inventory form, the guardian or conservator will list all of the ward's income, property, and debts. This form can be found at the following address. Information to report on this form includes the ward's cash, income, bank account balances, credit card balances, real estate property, personal property, vehicle, investments, retirement accounts, insurance policies, loans, mortgages, etc. The annual report of a guardian is a form that the guardian submits to the court at least one time per year. It is due within 12 months of the fiduciary appointment and every year on the anniversary date of the guardian appointment. For example, if you were appointed the guardian of your ward in June, then the annual report of a guardian is due to the court every June. If there are questions about when a report is due, contact your local county office of the circuit court clerk. On this report, the guardian is asked to share with the court details about the physical and emotional well-being of the ward over the past year. Information gathered on this form includes the ward's place of residence, mental condition, physical health, social condition, services the ward receives including medical, educational, social, vocational, and other services, visits and activities the guardian has done for or with the ward, and reasons why continued guardianship is recommended or not recommended. A copy of this report can be found online at the following address. Management of the ward's finances is top of mind for many full guardians and conservators. Upon court appointment of the full guardian or conservatorship, a separate bank account, known as a guardianship account, should be opened in the name of the guardian or conservator on behalf of the ward. The ward's money cannot be held in an account solely under the name of the ward or solely under the name of the guardian. A typical guardianship account is titled in the following way. The ward's money must be kept separate from the guardian and cannot be commingled together. In addition to setting up a separate guardianship bank account for a ward, the following are essential for financial management on behalf of the ward. Do not make cash payments for the ward. Write checks for the payment of the ward's expenses. Use the memo line on the check to describe the purpose of the payment. Keep all bank statements, canceled checks, and receipts. These will need to be submitted to the court with other required financial reporting forms. If the court has ruled that a ward have a full guardian or conservator, a financial report must be filed with the court at least every 2 years. This report is expected to give a full picture of all of the ward's assets, income, and expenditures. The name of this report form is the periodic or final settlement of a guardian or conservator for a minor or disabled person. The full guardian or conservator is expected to manage all of the ward's monies through a guardianship bank account. The guardian or conservator will utilize statements from the guardianship bank account along with all canceled checks and receipts to provide the court all of the ward's financial information. Let's look at this form. This form has 3 sections. The first section allows space for the guardian or conservator to list all of the ward's assets and income, as well as expenditures, which is noted as disbursements on the form. To complete this section, the guardian or conservator will rely on bank statements, receipts, and other account records to summarize all financial activity. The second section, periodic settlements, request information about how the guardian or conservator is preserving the ward's assets totaling over $5,000. The third and final section is reported on when a guardian or conservatorship is ended or when a ward is deceased. Here, the guardian or conservator will remark on the final settlement of the ward's estate. A copy of this form can be found online at the following address. Reporting on 2 years of financial activity can be a lot to remember. Wise guardians and conservators will create a system for monitoring and managing a ward's money. Here are a few ideas to consider. Keep a ledger to check and balance bank statements and receipts. Create a budget for the ward's money so the guardian or conservator and ward can both have a clear expectation of how the ward's money is spent each month. These tools will help ensure that the guardian and conservator's financial reports to the court are accurate and complete. Limited guardians, full guardians, limited conservators, and full conservators are entitled to reasonable compensation for services rendered and to reimbursement for reasonable and necessary expenses incurred in the exercise of their assigned guardianship or conservatorship duties and powers. Such compensation and reimbursement shall be paid from the financial resources of the ward and shall not exceed a commission of not more than 6% of the income collected by the fiduciary, payable at the time the income is collected, and b, either, but not both of the following as elected by the fiduciary. 1, an annual commission of 0.3% of the fair market value of the real and personal property in the care of the fiduciary, or 2, An annual commission of not more than 6% of the fair market value of the principal distributed by the fiduciary, payable at the time the principal was distributed. Upon submitting proof showing that in the handling of the estate the fiduciary has performed additional and necessary services which have been unusual or extraordinary and not normally incident to the care and management of a similar estate, the court may allow the fiduciary additional compensation as in fair and reasonable for the additional services rendered. In the event that a respondent may be in danger of serious impairment to his or her health and safety, the court can expedite guardianship proceedings. Examples of qualifying emergencies could be medical, psychological decomposition, financial exploitation, or a combination of these issues. In Jefferson County, emergency petitions must be approved by the county attorney. With this approval, a court date will be completed within 1 week of filing the petition application for emergency appointment of fiduciary for disabled persons, Form AOC 747. In addition to filing petition to determine if disabled, AOC 740, and application for appointment of fiduciary for disabled persons, Form AOC 745. Guardians, conservators, and wards may seek to change, modify, or terminate a guardianship judgment by filing the Petition for Relief, Modification, or Termination, Form AOC 795. There are a number of reasons on the part of the guardian, conservator, or ward as to why modification may be needed in a guardianship conservatorship court order. Completing this form allows the guardian or conservator to alert the court to these needs. Upon filing this form, a hearing will be scheduled within 30 days. This form can be found online at the following address. The Kentucky Guardianship Association has created a summarized list of all the information we have reviewed so far. It is called the Guardian Summary To-Do List. Number 1, open a separate Guardian's checking account titled Your Name as the Guardian for the ward. Number 2, file Form AOC 855, the 60-day inventory, within 60 days of your appointment. Number 3, pay all expenses for the ward from the guardianship bank account. Number 4, within 12 months of your appointment, file the Form AOC 790, the Annual Report of Guardian, to the court. Number 5, within 2 years of your appointment or at the direction of the court, file Form AOC 855 to the court. This form is titled Periodic Final Settlement of a Guardian or Conservator for Minor or Disabled Person. Number 6, create a plan for preserving the ward's estate, including any personal property and real estate. Number 7, invest the ward's money into an interest-bearing account or, if appropriate, an investment account. Number 8, if possible, have a standby guardian appointed by the court in the event that the guardian is unable to act. Number 9, do not use the ward's money for your own purposes or loan the ward's fund to others. This conduct is interpreted as exploitation and abuse. Number 10, any gifts of the ward's resources must be approved by the court. Number 11, in order to sell any real estate owned by the ward, a guardian must have a court order approving the sale, and all heirs must be notified of that intention. Number 12, a guardian is limited in what the guardian can approve. Medical procedures like abortion, sterilization, electroconvulsive therapy, and most psychotropic pharmacy intervention require court approval. A guardian cannot force a ward to take medication or seek mental health treatment. When in doubt, seek input from the court. Number 13, if you perform extraordinary services for the respondent or the ward beyond the normal guardianship services, seek court approval for any additional fees beyond the amount permitted by the statute. We started this presentation stating that guardianship is only considered as a last resort when other, least restrictive options are inadequate. Many individuals' rights can be lost through guardianship, so it is not a matter to be taken lightly. We hope that after participating in this presentation, you have a better understanding of the intended uses and requirements for guardians and conservators. Now we would like to take time to discuss a few less restrictive supports that must be considered prior to initiating guardianship. These alternatives include durable power of attorney, supported decision making, representative payee, healthcare surrogate, and joint bank accounts requiring dual signatures. A power of attorney, POA, is a legal document where one individual, the principal, gives authority to another trusted person, the agent, to act on behalf of the principal to the extent of the terms stated in the document. This document can include authorization for financial as well as healthcare-related affairs. A POA may be used if the person who is granting the power of attorney, the principal, fully understands what they are authorizing another individual to do. A POA may be written to continue in the event the person becomes disabled. This type of document is called a durable power of attorney. A POA can be revoked or modified at any time. This type of legal document allows a disabled individual, the principal, to maintain his or her own rights while legally authorizing another individual to assist as needed. Supported decision-making is a process of supporting and accommodating an adult with a disability through a trusted network to enable the adult to make his or her own life decisions, including decisions regarding the services, supports, and medical care they want to receive without impeding their self-determination. For more information regarding supported decision-making, please visit the following web addresses from the Council on Developmental Disability and the ACLU. A representative payee is an individual who has been given authority by a government agency to receive and manage funds on behalf of a benefit recipient to governmental programs like Supplemental Security Income, also known as SSI, or Social Security, or the Veterans Administration. The payee is determined through the government agency and does not involve a court's determination of disability. The payee has no legal authority beyond managing income from that particular agency and has no legal authority to make personal decisions on behalf of the recipient. A healthcare surrogate is an adult who is appointed to make healthcare decisions for you when you become unable to make them for yourself. This appointment goes into effect when a physician determines that an individual is unable to make their own healthcare decisions. This type of support can only be accessed when there is not already a durable power of attorney document in place with authority regarding healthcare decisions. A healthcare surrogate, once appointed, can make a wide variety of healthcare decisions. To learn more about healthcare surrogate, please visit this following address. A disabled individual may decide to have a joint bank account requiring 2 signatures to receive financial decision-making support while also learning to develop his or her money management skills. This type of account should only be established with a trusted and responsible friend or family member. Thank you for your time and attention to this presentation. The topics we have reviewed have a profound effect on the lives of many people. We hope the information shared in this presentation helps you to feel more informed. The Council on Developmental Disabilities is honored to be an established resource in our community. Please stay connected to us by visiting our website at www.councilondd.org, as well as our Facebook page. We also can be reached by phone anytime by calling 502-584-1239. Thank you.